Hello, yes, we're still in Unit 1, Chapter 1, but we're making progress. So we're going to talk about the purpose of law and the sources of law. The purpose of law, if you were to stop, let me give you about 2 seconds while I take a sip of my coffee. Stop and think about why you think we have laws. I bet you could come up with a bunch of reasons, right? The law does have a purpose. The law is meant to peacekeep. We have laws that actually check government power and promote personal freedoms. That's the Constitution. We facilitate planning and realization of reasonable expectations. We're going to learn that through contracts and a lot. That's why we have contracts. Promote economic growth. There is a lot of administrative agencies that we're going to talk about in just a second that help us promote economic growth. Promote social justice, protect the environment, protect people. There are a lot of reasons that we have the law. And it's important. Why do we care what the purpose is? The law is the law. It's important when we're looking at trying to apply law to a certain situation. Because if we know why the legislators passed the law, then we can determine what it applies to. If we kind of understand what the Constitution is and the purpose of certain things in the Constitution, we can interpret the Constitution a little bit better. So we look to what we call intent. So purpose is really gives us insight to intent, which helps us when we need to interpret law, which seems to be the majority of what we do as lawyers, is interpret laws to situations. Actually, it's all we do, to be honest. So let's talk about the law, the highest law of the land, the Constitution. But prior to the Constitution, the state actually had their own constitutions. And then the US Constitution came along. And what are our big three? Our big three, it empowers government. How does it do this? Enacted laws. It allows the government to make laws. And we call those laws enacted laws. Enacted laws are laws that the government makes, but it limits government. We're going to talk about that when we talk about the Bill of Rights. There are certain things that the government cannot legislate. They cannot take away from us our basic freedoms and those that are listed in the Constitution and the Bill of Rights. And that's a limitation on government. And it tells us the Supreme Court is the law of the land. Any law that conflicts with the US Constitution is unconstitutional and what? Void. Nada. Never existed, right? State constitutions. State constitutions cannot conflict with the US Constitution, nor can they conflict with federal law. Remember, supremacy, federal supremacy. We always have to go, does the federal government have power here? Do they already have something in place here? And if it does, the states have to adhere to it. It cannot conflict, because what if it does? It's void. Nada, never existed. So that gives us constitutions and what our constitutions are. But we have another form of law, which we probably all think about when we think of law, and those are our enacted laws. And it talks about in your book other laws, treaties, and executive orders. And I want you to understand those from your book perspective. But really, what's important when we're talking about business law is statutes. What are statutes? Statutes are the written laws by governments, by our legislators. So you can't speed, you can't go try more than 25 miles an hour in this zone. This is a statutes. If it's at a city level, sometimes we call them ordinances, but they're laws. That's what we think of as law. But we also have administrative agencies who put together regulations. And these regulations are basically, or not basically, but they're the law. And why do we have administrative agencies? Well, administrative agencies are things like our occupational safety hazard agency, OSHA, that you may have heard of. Or we have the FDA or the EPA. All these agencies, what are they? Okay, let me break it down in a nutshell. We have Congress, and they're there to pass all our laws. But there are certain areas of law, areas of not necessarily even law, but scope of things that are so large to handle that they cannot pass every single law on safety and hazard, for example, occupation safety and hazard. So they put together an agency and they say, this is the scope of what we want you to handle. You get to make the laws, and you even get to have, there's courts, you get to even determine if the laws are broken, you can decide. So administrative agencies, they're called regulations, but they're enacted law as well. So these are all another type of law, okay? And again, where the government gets authority to make those laws? Our Constitution, okay? So you're seeing we have our laws and then we have our Constitution. So then we have something that happens is, what if a law is not made in a certain area? Or what if we don't understand exactly what the law means? Who decides? That's going to be our judges. And that is going to come from our English roots. So when we had the American colonies, they went under the British rule, the English rule. And what they did is they had judges over, and the judges would make a law and apply it to facts. And that was called precedent. They would then take that law that they made, and if they had a similar issue and similar facts, they would apply that case to that law. And that's called the doctrine of stare decisis. And that means let the decision stand. So we should decide cases alike. Decide the case how the other case is decided. And that comes from our English roots. Particularly when we first came over and we didn't have all these statutes written. Now it tends to be more when we need to interpret a statute, because obviously when the legislators write a statute down or regulations down, they're not going to write every single scenario it applies to. And so what we have, this area of law, we call common law. Some people call it case law because you're taking a case that's been settled, that has a similar fact and issue, and you're going to apply it to your case. And some people even call it judge-made law. We were told that judges only interpret the law. They really do make the law. You'll see a lot of that. So let's use an example because I think it'll be easier. And this is just a total hypothetical that I made up. So let's say we have a statute that says all gambling is illegal. And gambling is defined as a game of chance. But it doesn't include a list of activities that's considered gambling. It doesn't say dice and bingo and roulette and poker, okay? It just says gambling is illegal, or maybe it includes all of those things, but it's not an all-inclusive list, meaning it's not exclusive to those things. So it says some examples, or it says to include but not limited to bingo and roulette and dice and poker. And so what we have is defined as a game of chance. Now we have Susie Jones, and she's arrested and she's charged under the statute for betting on horses. And the statute doesn't say whether or not horse racing is gambling. So we have case state of Kansas versus state Susie Jones, or state of Missouri. Either way. And what we need to know is, how is Susie going to defend this? What is her defense? She can't say, I didn't know it was legal, because if it can be interpreted, if a normal person can interpret it, you can say, hey, you can't use that as a defense. So what is she going to say? She's going to say what? It's not a game of chance. If it's not a game of chance, it's not gambling, right? So the court has to determine whether betting on horses is considered gambling. So it has to determine if it's a game of chance. Once the court decides this case, state of Kansas versus Susie Jones, future cases that come up that regard the same issue and are on the same or similar facts, the courts will use as law. The law is state of Kansas versus Susie Jones, unless A court that is at the same level or higher overturns this decision, but case precedent is to be followed. It's very difficult, or should be very difficult. We'll see, it's not always that difficult, but to overturn precedent. Or what can we do? The legislators can change the statute. Because what are the judges technically doing? Interpreting the law. They're not making the law, although they are, because other cases that follow until the legislator says something have to be followed, right? But that's a big different debate. The legislators then could go back in and exclude horse racing. And then this is no longer considered good law because we have to listen to the statute first. But the question is, how does the court determine what chance is? It's up to them, right? So you can look to definitions. What's a definition of chance? We can look to intent. Remember what I said? I said we look to reasons, the purpose. Did the legislators implement this legislation because of corruption and crime rate increase and compulsive gambling? And did those things occur in horse racing? If so, the judges can use that in their decision when they interpret whether or not horse racing applies to gambling. Let's look. Other thing we can do is look to precedent. Has another court decided anything like this? Let's say we found one and the court says it's a game of chance. It defines it. So it doesn't apply to horse racing and it doesn't really apply to any kind of racing, but we found a definition. And it says it's determined entirely or in part by lot or mere luck. The throw of dice, the turning of the wheel, the shuffling the cards are all modes of chance. A game of skill, however, is one in which success depends principally on the superior knowledge, training, attention, experience, and adroitness of the player. So we have precedent. We're going to take this law because it's out there and we're going to see, will it help us here? And does it help us? Well, the issue's a little more complex here, right? Because what? Susie's going to argue, wait a second, this is a game of skill. It's a systematic sport. Participant has to have full knowledge about the horse, jockey, trainer, owner, the turf, the composition of the race. It depends primarily on a special ability acquired by training. Between two equally fast horses, a better trained jockey can be the first past the post. And more importantly, it's a skill to analyze and study all this information with respect to horses, jockeys, and racing. It's skill. I don't win by chance. I have this skill down. And the government is going to say, no, Susie, you broke the law. This is a game of chance. Because most of the viewers are induced to place the bets, though they have no knowledge of horse racing or the game on whose outcome they are placing a bet, or have no inclination to acquire that knowledge. And there's a difference in your participating in a game of skill for money, meaning there's a difference in your argument that all these people are trained to horse race and the outcome of it. So we have an argument for skill and chance, and it doesn't really help us a ton. But guess what? What if we find another Supreme Court and it says that a game involving both skill and chance would be characterized as a game of chance if the element of chance predominates over the element of skill, and a game of skill if the element of skill predominates over the element of chance? So I just need to decide as the judge which one predominates. Now this is where it's interesting, because you could grab 10 different judges and you may have different answers, right? Of what is skill, what is chance, which one predominates. But guess who gets the lucky draw? The judges that it's up before. So in this case, the court basically has to decide what is more important. And let's say the court comes down and says the element of chance in horse betting predominates over the element of skill. Horse betting is game of chance then, and it's considered gambling. What does this mean? This means this is our law. From now on, if anybody has a question about whether horse racing is a game or is gambling, you reference State of Kansas versus Susie Jones. Now, again, let's say the appellate court decide this, the Court of Appeals, and we're going to learn the trial court levels, so don't worry too much, but the Supreme Court is higher. And let's say we are talking about the state here. The State of Kansas Supreme Court decides to take it on review, and they can reverse that decision, and then their law is the new law. Or later down the line, long time down the line, for some reason, the equal level appellate court decides that's not great law, we're going to overturn it, which is supposed to be hard to do again, but not always. Then that's what we have. So in a nutshell, what we do is we take the case and we apply it to the other cases if there's no law on it. Why do I say that? Because we have a hierarchy of law. We have an order of which law is superior. The Constitution. Nothing can conflict the Constitution, otherwise it's void, never happen, right? Then statutes and regulations that are constitutional take precedent. Then we go to common law and case law. So if common law and case law has been decided, but there's a new statute that says, that's not what we meant, then that common law and case law is no longer good. And that's our hierarchy of law. Now, we always have to remember federal law trumps state law. So let's say there was a federal law that says we have a right to gamble as it's a fundamental right in our Constitution, which it's not one of the fundamental rights, but let's say it is. That means that the state cannot take that right away. They can regulate it, but they can't take it away, and therefore would not be able to pass a statute that said gambling is illegal. And that's where the federal law trumps the state law. We're going to talk more about this as we go through, so don't feel overwhelmed. What's next? The next thing that we are going to be talking about is types of classifications of law in the context of a case and building a case. So we will see you then.